back to the show. This is The Law Show on CL 650.
Say you will.
And welcome to The Law Show on CL 650. I'm Zach Spencer, and we're talking about wills and estates. We have from Macquarie Hunter, Alyssa Lockhart, partner, and Leah Donaldson, associate. And you're located in Central Surrey. Surrey Central. It has two names, doesn't it?
And Wally.
But you are right where the SFU campus is, right?
We are right in the shopping mall tower at the SFU campus, very close to, right across the street from the SkyTrain and very close to City Hall.
Yes.
And the other thing I say is that you're centrally located for the greater Vancouver area, Metro Vancouver. So to the north, you have the Tri-Cities. You have to the east, you have the whole valley. To the south, you have New West and Vancouver to the west. So you're really right in the middle of the whole greater Vancouver area. So it's
and
easy
our partners and associates live all the way from the North Shore in downtown Vancouver all the way out to Mission and Langley and Aldergrove.
So when you're planning a will, you need to have certain documents that you need to bring. So what are the things that you need to have when you're planning your estate?
Well, people will often put off booking an appointment because they don't think that they have everything together. And I will tell them, don't put off booking the appointment, because this is the best quiz you'll ever be given. You already know all the answers to my questions.
Really?
Except the ones that I give you pause for thought on. So yes, it's great to put your document package together and bring it to the appointment. Your insurance documents, your financial investment documents. It's nice to know for the planner, how much are we really talking about? Because the way you hold an investment, say a closed or an open account, a closed account you can leave a designated beneficiary on. An open account, that will flow to your estate after you pass away.
So can you give us some examples? I guess a closed one is life insurance, for example.
A closed account would be like an RRSP, a RIF.
Okay.
An open account would simply be an equities file at your investment planner's office that is not registered. So it might be joint with a spouse, but at the end of the ownership, when that person passes away, it will flow to an estate rather than outside your estate the way an RRSP or a RIF might, or a TFSA would. So it's nice to know how you hold your assets, and if you hold significant assets, we might say, now it's saving for a rainy day. It's very Canadian of us to sock it away and end up with significant assets in that registered vehicle. On the death of the last spouse, when we can't roll it on a tax-deferred basis to another spouse, we're going to pay tax on the date of death as though that was our income in that year.
Right.
So your highest year of income might be your year of death.
Right.
And the intent of socking it away is never to give it to the tax man. Right. So those are the documents you might want to have a look at before coming in, and it's great if you can bring them. But the documents that we create, I think the bigger question for clients is it just a will? Is that an estate plan? And it really isn't. We have clients who already know about the power of attorney, already know about the healthcare representation agreement, but they don't know that if they put something into a joint holding with one of their children, and they actually intend not to simply avoid probate processes, but they actually intend for that one child out of many children to receive that asset upon death, that maybe we should do a gifting letter. Maybe we should make that clear in order to protect it.
Can you give me an example of that?
Well, I have clients who have a separate bank account that they've always maintained for each of their children. And then two of their older children receive their bank account. They get married or they buy their first house. Their younger child, 23, still in university, hasn't touched that bank account. But mom puts it on jointure because she's thinking, now I'm getting older. I might not be around to write the check. My daughter might need to inherit that directly. And what if there's been a falling out between siblings? What if the estate isn't very large? What if the executor isn't familiar with those previous two accounts that have already flowed to the older children? Does somebody try to draw that account back into the estate and say that jointure was for estate planning purposes, it wasn't an actual gift over? So the gifting letter can make that very clear. So there's a number of different documents we might create. If we are writing out a child, you spoke of that earlier, if we are doing an inequitable distribution, I'd want a statutory declaration from my client setting out the whys and the rationale, and outlining and identifying how they meet that test that Leah talked about, so that it's clear that they have provided fairly, justly, and adequately for all of their family, even though they're not attached to those assets. So
how high is the bar for that?
It's really dependent on several circumstances, but what Alyssa's talking about, so say the gift letter or the statutory declaration that provides an explanation as to why you're, say, disinheriting one of your children, provides for us, the estate litigators, a wealth of knowledge and understanding of what that will maker was thinking at the time. So there might be very good reasons for someone to disinherit one of their children. And if you've set those out with your estate planning lawyer, then from our perspective, it makes it a lot easier for the estate litigation lawyers to understand what was at play there and hopefully settle the matter before it even, say, turns into a lawsuit. Mm-hmm. So that's one of the documents that you don't normally think of when talking about just making a will or doing estate planning that can be very important.
So you have a situation where, say, one child is not included in the will, and then you have this documentation to back it up. And once they've read it, they go, "Well, there's really not much you
That's
can do
right,
about
or
it."
their lawyer will look at it. So, for instance, if you gave that child a gift of $500,000 previously in your life, or say only $100,000, if that's written out, then we have the evidence right there of what the rationale was behind that. And actually, when you look at it that way, now we see that all children are actually taking equally. Mm-hmm.
Mm-hmm. All right. So any other documents or things you need to think about? And I want to get back to the point you made. You know everything. What do you mean? What do you mean by that? You don't need to bring the documents. You know.
Oh, you already know everything.
Yeah.
As a client, well, you know all of your personal data. What was your date of birth?
Right.
What city were you born in?
Right.
Who are your children? How many children do your children have?
It's all the basic stuff.
All of the basic stuff. Everything that I might want to know, so that I can say, I see that when you came in and you said, don't ask any questions, I already know exactly what I want to do. I want to leave everything to Susie. Now you've told me about Johnny. Well, tell me a little bit more about Johnny, because maybe Johnny's going to make a claim after you pass away. Mm-hmm. So these questions, yes, it's personal and I'm very inquisitive, but when we get down to it, it protects the client. So the client will come with preconceived notions about how the interview might go. And I like to just have a conversation about what their life looks like, who the people in their life are and what they mean to them, and what their assets are, and what would be their big ask of the way that it's distributed after they pass. What would be their perfect world?
Do people withhold information from you? They're trying to... What do you have to say about that?
People have tried to withhold information from me, but well, that would be my ex-husband probably, right? It doesn't last very long. No, I shouldn't joke. But no, sometimes people really do feel that it's a very private matter, but I find that less and less often as the years go by. And my style is very casual. I'm not an intimidating three-piece suit lawyer, and people realize very quickly that when I see that they're trying to withhold or be very narrow in their answers, I'll just jump into an example from my own life. I spend a lot of time mostly with clients from blended families and who have corporate assets or significant personal assets. Those are areas that have touched my own personal life, and I'll just start sharing, and then clients will start sharing.
I've noticed you like to share your personal stories.
Perhaps
people relate to that, though.
People do relate to it. That is actually the style that I've adopted in my practice, because it helps the document be a better document for the client. But the one document we haven't really talked about today that I think maybe Leah can make some comment on is the power of attorney. Mm-hmm. If you don't have a power of attorney, and people will say everybody needs a will, mm-hmm. If you have to make a choice on, say, price point or just timing or any other factor, choose the power of attorney more than the will. I can tell you exactly what's going to happen if you die without a will, because WESA tells me what's going to happen. Mm-hmm. It may not be what you want, but at least there's certainty. If you become incapacitated without a power of attorney, I can't even begin to write the first 100 chapters of that book.
Huh.
So maybe Leah could talk about that?
Yeah, and that's because you have not named a person that has the power to step into your shoes if you were, say, in a car accident or you had a stroke and you weren't able to make any decisions on your own. You haven't named a person that can step into your shoes and deal with your assets. So you're basically putting your family or your friends, if you don't have family, in a position where they're forced to come and see an estate litigator or sometimes estate planners to make an application to court. You need a court order to deal with people's assets if there's no power of attorney in place. So it's not cheap, and it's definitely more complicated than simply walking into an office and naming someone as a power of attorney. So we always recommend that that's a very important document to get done.
And what are the costs typically to get a power of attorney done?
It depends on whether you're an existing client and we know you. We already have a lot of the information. We can take instructions quickly. It depends whether you're doing multiple powers of attorney back to back between spouses or siblings, perhaps. It depends whether you're doing a package of other documents, because the document itself can be relatively straightforward. So it depends on the time it takes to draft for us.
So lots of variables.
Under $300,
oh, okay.
Sometimes around $200.
Right.
But when it's part of a package and we're doing wills for spouses, we're doing representation agreements for spouses, we're doing powers of attorney for spouses, if you actually broke down the invoice at the very end of the day, it would be almost a loss leader product for us,
right,
because our time and our drafting actually goes in the other documents more so.
Yeah, that's more heavier on that end.
Absolutely.
So in our last minute here, I could almost tell you what the advice is. If you haven't had a will or estate planning, you need to speak to a lawyer, right?
Yes.
And that's pretty much it?
Absolutely. Don't try to do this on your own.
Can save your family a lot of time and stress and money after your death.
Everybody has a personal story about how families have been ripped apart when someone passes away, and then they fight. Those are the biggest fights in families, isn't it?
Yes, absolutely. And I tell clients that the first argument your children have after you pass away is the first one you can't say, shush, leave your sister alone.
Go to your room.
Right?
Exactly. Well, thank you very much for your time today. It's been very interesting. You made this subject very interesting, so congratulations to you both.
Thank you.
Thank you.
Obviously talk about exactly what you do every day. It's a great wealth of knowledge. Alyssa Lockhart, partner at McQuarrie Hunter, and Leah Donaldson, associate at McQuarrie Hunter. Thanks for your time on The Law Show. We'll have you back soon. I'm Zach Spencer. We'll speak to you next time on CL 650.